You're driving to buy a used car. You have $6,000 in cash. Police pull you over for going 2 miles over the speed limit. They ask if you're carrying cash. You answer honestly. They take it. You're never charged with a crime. You're never convicted of anything. You never get your money back. This isn't theft. It's legal. It's called civil asset forfeiture. And since 2000, according to the Institute for Justice, law enforcement has used it to seize approximately $68.8 billion from Americans. The legal trick that makes this possible? The government didn't sue you. They sued your money. The case name reads, United States versus $124,700 in U.S. currency. 2,000 years ago, Roman authorities had a system for seizing property without trial. They called it proscription. The legal fiction that makes modern forfeiture possible is older than the Constitution. Civil asset forfeiture operates through what lawyers call in rem procedure, Latin for against the thing. The government sues property directly, not its owner. This produces case names that read like absurdist fiction. United States versus one assortment of 89 firearms. State of Texas versus one gold crucifix. The Supreme Court has acknowledged what this means. Property is held guilty and condemned as though it were conscious instead of inanimate and insentient. In criminal forfeiture, the government must prove guilt beyond a reasonable doubt, approximately 95% certainty, before taking anything. In civil forfeiture, the standard drops to preponderance of evidence, just 51% probability. And the burden often flips. You prove your property is innocent. You prove you didn't know about alleged criminal activity. You get no right to appointed counsel. You're on your own. This concept, that objects can be guilty, should have died in 1846. Medieval England had a doctrine called deodand. From the 11th century until Parliament abolished it, any object causing accidental death was forfeited to the crown. A horse kicks someone? Forfeited. A cart runs over a child? Forfeited. A tree falls on a farmer? The tree is guilty, forfeited. The legal fiction treated inanimate objects as capable of wrongdoing, regardless of the owner's culpability. Parliament recognized this as absurd and eliminated it nearly 2 centuries ago. But the concept crossed the Atlantic. It embedded itself in admiralty law. It survived. The Romans took it further. They didn't just seize property, they seized people. In 82 BCE, the dictator Sulla introduced proscription. Authorities published lists declaring certain citizens enemies of the state. The moment your name appeared, you lost citizenship. You lost legal protection. You lost everything you owned. No trial, no charges. Just a list. The Second Triumvirate expanded the practice in 43 BCE. Over 2,000 landowners and 300 senators were proscribed. Their estates financed a civil war. But here's what matters: the incentive structure. Assassins who killed the proscribed kept part of their estates. Informers received bounties. Enforcement was profitable. In 1984, Congress gave American police the same deal. The Comprehensive Crime Control Act of 1984 transformed civil forfeiture from a customs tool into a national law enforcement strategy. It created the DOJ Assets Forfeiture Fund and established the Equitable Sharing Program. The arrangement works like this. State and local police seize property, partner with federal agencies, and keep up to 80% of what they take. The federal government keeps the rest. The fund's growth tells the story. In 1985, the DOJ Assets Forfeiture Fund held $27 million. By 2014, it exceeded $5 billion, but the money was only part of the design. The program also created a mechanism to bypass state protections. Through adoptive forfeitures, local police seize property under state law, then transfer the case to federal agencies for forfeiture under more permissive federal rules. California enacted strict state protections. From 2000 to 2013, California became the top recipient of equitable sharing proceeds. The Institute for Justice found that agencies in states with more restrictive forfeiture laws receive more federal equitable sharing money. The system incentivizes circumvention of democratic reform. Between 2000 and 2019, $8.8 billion flowed to state and local agencies through this program alone. By 2014, police were taking more than criminals. That year, combined federal forfeitures exceeded $5 billion. The FBI estimated total U.S. burglary losses at $3.5 billion. For the first time documented, government seizures surpassed property taken by street crime. The DEA alone reportedly seized $4 billion in cash over the decade preceding 2017. According to the DOJ Inspector General, $3.2 billion of those seizures were never connected to criminal charges. Only about $153 million was returned. The overall return rate? Approximately 1%, and the people it targets can't afford to fight back. 88% of forfeitures go uncontested. The economics make challenging them irrational. The median seizure is worth less than attorney fees. 93% of DOJ civil forfeitures were administrative. meaning no court hearing ever occurred. Half of all state currency forfeitures are worth less than $1,300. These aren't drug kingpins. These are ordinary people. The cases that did reach court reveal what the system actually targets. Tanaha, Texas, population 1,000. Between 2006 and 2008, according to an ACLU lawsuit, police seized approximately $3 million from at least 140 motorists on Highway 59, almost exclusively black and Latino drivers, pulled over for infractions like driving 37 in a 35 zone. The choice allegedly presented: sign over your cash and valuables immediately, or face felony money laundering charges and have your children placed in foster care. Jennifer Boatwright and Ron Henderson were an interracial couple traveling with 2 children and $6,000 to buy a used car. According to court documents, they were forced to sign a document stating no criminal charges shall be filed and our children shall not be turned over to Child Protective Services. An exchange of rights for property, documented in writing. Tanaha wasn't an outlier. It was a business model. Philadelphia operated what the Institute for Justice called a forfeiture machine. Between 2002 and 2014, the city reportedly seized 1,172 properties, 3,500 vehicles, and $50 million in cash. The median cash seizure, $178. When police caught the Sorvellis family's 22-year-old son selling $40 worth of heroin outside their home, according to court documents, they moved to seize the house. Neither parent was charged with any crime. The racial pattern was documented. African Americans constituted 44% of Philadelphia's population, but suffered 71% of house seizures. Then departments started building budgets around it. According to the Institute for Justice, top forfeiture-earning agencies in Texas derive approximately 37% of their budgets from seizure proceeds. A DOJ investigation found that Ferguson, Missouri, drew 1/5 of its municipal operating budget from court fines and forfeitures by 2013. Internal emails obtained in the investigation showed the finance director instructing police to generate revenue increases. The municipal court issued 32,975 arrest warrants for a city of only 21,135 residents. The Desert Snow Training Program reportedly taught officers to view highways as revenue sources. A program official urged police to use cash seizures to bolster municipal coffers. In promotional materials, he wrote that departments can pull in expendable cash hand over fist. When economists studied the pattern, they found the motive. An empirical study found that a 1 percentage point increase in unemployment correlated with a 9% increase in forfeiture activity. The same study found that increased forfeiture funds had no meaningful effect on crime fighting. The researchers concluded that police pursue forfeiture less to fight crime than to raise revenue. The founders saw this coming. Colonial writs of assistance were general warrants authorizing searches of any property for smuggled goods. Customs officers received commissions on seized goods, profit incentives for enforcement. James Otis argued against these writs in 1761. John Adams witnessed it and later wrote, "Then and there the child independence was born." The constitutional response was direct. Article 1 prohibits bills of attainder, legislative declarations of guilt without trial. Article 3 limits forfeiture for treason to the offender's lifetime. The Fourth Amendment requires particular warrants based on probable cause. The Fifth Amendment guarantees due process before deprivation of property. The Eighth Amendment prohibits excessive fines. For a brief period, the government honored these protections. Alexander Hamilton's Treasury granted relief in over 90% of remission cases. The early belief? It was improper to take property from those who inadvertently broke the law. Modern courts have started to notice the contradiction. In Timms v. Indiana, 2019, the Supreme Court unanimously ruled that the excessive fines clause applies to states. Justice Ginsburg wrote that fines are uniquely dangerous because they serve as a source of revenue, creating improper incentives. Justice Thomas has emerged as civil forfeiture's most prominent judicial critic. In 2017, he questioned whether modern practices can be squared with the due process clause in our nation's history. He observed that the system frequently targets the poor and other groups least able to defend their interests. Roman prescriptions seized property through lists, no trial required. Medieval deodands treated objects as guilty, regardless of owner innocence. Colonial writs gave enforcers a financial cut of everything they seized. Modern civil forfeiture combines all three: seizure without conviction, guilty property, profit incentive for police. 84% of Americans oppose civil forfeiture. Both 2016 party platforms endorsed reform. Yet $68.8 billion has been taken since 2000. 84% of federal forfeitures are civil, meaning no conviction was ever obtained or required. The founders wrote an entire constitution to prevent this. The legal fiction that made it possible should have died with deodand's. The chains aren't physical. The extraction is legal. The pattern is ancient. They're running plays that are centuries old. Once you see the pattern, you can't unsee it, and you can't be trapped by it. Subscribe. The history they don't teach is the history that protects you. Position